Welcome back. I am the loud little ducky. Today in Owens v. Echard, we are going to go over Echard's reply to motion on fraud belief. And we have Owens over here, and the doctor says, "Where is the baby, ma'am? Where is it?" So we've got reply to petitioner's response to respondent's amended motion for relief based on fraud assigned to the Honorable Judge Matta, Owens v. Echard, and this is Woodnick. Defendant/respondent Clayton Echard, by and through counsel undersigned, hereby files this reply to plaintiff/petitioner Laura Owens' response to his amended motion for relief on fraud. Tampering with evidence is more than just a misstatement, and it is appropriately addressed in ARS 13-2809. Yes, it is way more than just a misstatement. Here, Laura has committed significant levels of fraud in both the order of protection proceeding at issue and during the course of the paternity action, also before this court. Yeah, at every point in this case and others, fraud. Notably missing from Laura's response in any acknowledgement that the sonogram at issue, which she finally admitted at deposition, was falsely attributed to Southwest Medical Imaging, SMILE, has also been confirmed not to have originated from Planned Parenthood, which we talked about before. It didn't come from SMILE. It didn't come from Planned Parenthood. Where the hell did it come from? Nobody knows, except for Owens. And we're expecting her to tell the truth? We'll never know. Moreover, via medical records from 2016, which are also dubious, Laura claims she had ovarian cancer and that she had an ovary removed, information that is patently missing from any of the medical records provided by Laura, including not being provided to her own expert, and which would have considerably impact on her ability to become pregnant had there been intercourse. Now I'm going to read the footnotes, and then I'm going to give my thoughts on this from my own personal experience. So footnote 1 says, note, Laura already admitted at her deposition to doctoring the sonogram, but avowed that she had obtained the original on July 2nd, 2024 at Planned Parenthood. Planned Parenthood has since confirmed that Laura was never seen there for an ultrasound appointment and had in fact canceled the July 2nd appointment. So she made an appointment but canceled it. She needed to be like, see, I made an appointment. Planned Parenthood also noted that the sonogram she claimed was from them was not consistent with the sonograms performed at Planned Parenthood. Yeah, it wasn't. Laura also claimed that there might not be records of this appointment because she made it anonymously, which Planned Parenthood also confirmed is not possible to do, as they do not offer anonymous appointments. Okay, footnote 2. Consistent with court's order that no medical records are to be publicly available, these medical records have only been provided to Laura. Okay, so those were the footnotes. Now back to him saying that for the experts, it would have been a considerable impact on her ability to become pregnant if she only had one ovary. Some say that it could be harder. And I'm not saying this in a bragging manner or whatever, but I only had one ovary from the time I was 13 on until I had both of them removed at 23. But it seemed like any time that I did the thing with my kid's dad and ex-husband and I wasn't on any type of birth control, there was no contraceptives or anything used, I seem to have gotten pregnant almost every time. Um, but but when I didn't, I made sure I stayed on top of my birth control. Um, so in my case, it didn't have um, an impact on mine unless if it was that easy with one, I don't even want to know what would have happened if I had had both of mine. Like, um, my ex-husband, we joke about we had sex as many times as we had kids and we didn't have any in between. That's our joke. Um, but that is my experience. So I don't know if it really would have been that big of a difference. Some say it can, because you don't have two ovaries producing like eggs and stuff. So maybe there would be more to choose from. It just didn't in my case. So I would give benefit of doubt on that if in fact she did have it removed or something. But she says she didn't. So there is no mention of John Chung Kail Chan, MD's records for Laura, who reportedly diagnosed her with real ovarian cancer, not something that just may be there. Or Rebecca Yee, MD records for Laura, who said yesterday, 8/30/2016, you received an ovary removal surgery, an oophorectomy of your right ovary, as well as a surgical abortion. I don't know that they would have done those at the same time. They might have, if they could do it. Well, I don't see them giving abortions laparoscopic, because you can, depending on the size of cyst in your ovaries, you can have the ovary removal surgery done laparoscopic. My case, it didn't work out that way, so I had to be cut open. And then they just ended up doing that again when I had the rest of it removed. They would have called it an oophorectomy. They wouldn't have called it an ovary removal surgery. Also, they tell you that they're going to test the cyst and stuff to find out if it is cancerous or not, if it's benign or malignant. In my case, thankfully, they were benign. And so far, it seems like all of her cysts that she's had with the PCOS, the polycystic ovarian stuff, which I don't know if that's true, because she could be lying to them about that too. But it seems like all of hers have been benign as well, which is a good thing. That's what you hope for. All right, let's move on. As and for his reply, Clayton states as follows. Laura's response begs the question why this court must set aside her protective order, which was procured based on fraud. Fortunately, this court ordered petitioner to attend her deposition. She had previously failed to appear and provide disclosure pursuant to Rule 49. She had provided insufficient information prior to this court's order and then continued to not comply, prompting in the eventual order to compel. Those discovery and disclosure processes revealed that Laura had modified medical records that were used in the, I'm guessing, order of protection. But let's see. In the underlying paternity matter and in the collateral protective order matters. More shockingly, it exposed Laura's history of fabricating pregnancy claims and medical records extends to at least 3 other men. Laura's response to amended motion to set aside is a lesson in fallacies. It has all the classic trappings of false authority, non sequiturs, suppressed evidence, and red herrings. As referenced, the data set Laura's medical experts relied on is missing key foundational information. ostensibly because Laura failed to share the information with her own expert. Her medical expert and his report will appropriately be objected to at trial under Rule 702 and Daubert. So I agree with that. It also, in that video, is missing Maraschini's pregnancy and Greg Gillespie's pregnancy, as well as the one from possibly 2014. Because it lists Clayton's and then it lists the 2019 pregnancy. And we don't know who 2019 pregnancy is. Because that was not Michael Maraschini's pregnancy. Because they were broken up in 2018. So we don't know who's in the middle. So there's a lot that this medical expert doesn't have. The response uses fallacies in a distorted attempt to avoid the realities of ARS 132809 as by Laura's own admission and has confirmed by Smile and Planned Parenthood. Laura tampered with medical records and despite this used them as evidence in court proceedings. Laura refers to this civil and criminal punishable behavior as some misstatements. Yes, this is criminal behavior. Punishable criminal behavior. A scam artist, con artist, a serial criminal who does fraudulent documentation. How is this any different than making fraudulent birth certificates, driver's license, any of this stuff, degrees that people, like the doctors that pretend they're doctors but don't actually have a real degree, they just have a fake diploma from Harvard or something. Like, this is that, except for in pregnancy world. She deserves to go to jail, and it would be all of her fault. This is not the first time Laura has tampered with medical evidence, which is relevant as a sonogram was the basis for Laura's OOP being upheld. To be clear, Judge Judy clearly stated as the conclusion of the order of protection hearing that he was upholding the order of protection because of the sonogram in the image at issue, which was the Halloween costume photo. Laura appears to prefer to diminish the importance of the sonogram that she altered and presented as evidence. Had Laura re-listened to the audio from the hearing, which Ninja Schnitzel has up, so she could go do that on her own, she would recall when he made his decision, Judge Judy said, "The way you published this photo, it's unflattering. That's my reason for making my decision." And that was on October 25th, 2023 at 10:01. Laura is prolific with her arts and crafts skills. Upon information and belief, the same tampering occurred in prior pregnancy fraud matters, so much that in at least one instance, the actual patient whose records were falsely attributed to Laura in the blank matter, which the court took judicial notice of, has stepped forward to share the trauma of seeing her medical records bearing Laura's name and the stolen valor of the tragic pregnancy loss via phenomenon known as vanishing twin syndrome, VTS. Footnote 3. Oddly enough, Laura's counsel blogged his theory and that Laura has experienced this rare phenomenon. What the hell is a vanishing twin? We did cover that in the David Gingas, whatever his name is. We have covered that one that he posted on April 18, 2024. Goes on to say, to be clear, there are 3 ultrasounds that have been altered. 1 image used in the order of protection, current proceeding, 1 video, and 1 21-week sonogram. The first is the one that has been confirmed to not have come from Planned Parenthood nor Smile. The second is an ultrasound video dated September 5th, 2023 that Laura now claims was faked by one of her prior victims. The video was sent from Laura's email, contained her biographical information, and Laura sent it to Clayton Steve Carbone, which is Reality Steve. Exhibit 2. Upon information and belief, once Laura realized the video she sent to Clayton and the media was identical to the publicly accessible video online from years ago, also falsely attributed to Smile. She backpedaled and emailed Clayton on October 14, 2023. This afternoon, I opened the file labeled Sonogram 9523. I'm 100% sure you won't believe me, but I had a different sonogram video with that title that I uploaded weeks ago. Emphasis added. Exhibit 3. To date, that different sonogram video has not been disclosed. Yeah, because she saved this fake one under that name because there wasn't a real one. I 100%. People that talk about 100%, the 1,000%, people that talk in percentages are lying. People that are just saying it like they are, we don't need to speak in percentages. We don't need to add that extra emphasis. But people that are skirting the line, whatever, 100%. No. No. People that are telling the truth don't speak in percentages, in my opinion. The third is a sonogram of a fetus that appears to be 21 weeks and 3 days old. This sonogram was sent from Laura's email on October 12, 2023, bears the last name Owens, and was sent to the media with commentary from Laura that the last imaging I had was troubling to me because I thought the boy's profile looked kind of weird. Attached, but the sonographer didn't say anything. The sonographer, the person doing the ultrasound, they're not allowed to say anything to you. They're not supposed to tell you whether it looks good, it doesn't look good. They're not supposed to tell you jack squat. If anybody's been pregnant and had to go through that, and it's not been with their doctor, but you've had to go to the emergency room and then have somebody come in, or even when you're in labor and delivery, and they have the people come in for an ultrasound that's like through the hospital, they don't tell you anything. You have to wait for the doctor to tell you what it says. Because they're not allowed to, because they're not a doctor. So when they know what they're looking for, and a lot of them do know what it is, they are not legally allowed to say anything. So, yeah, that's why they didn't say anything. Or they wouldn't say anything if this was true. Exhibit 4. This sonogram has not been disclosed, nor have any communications supporting Laura's repeated claim that she was pregnant with boy and girl twins, despite the motion to compel requiring the same. Upon information and belief, Laura opted not to disclose the sonogram or provide it to her own expert because it does not comport with her new July/August miscarriage timeline. 2. Laura's appended expert report and her counsel shared the same on Twitter are contrary to court orders and Laura's repeated claims that she was in need of protection. Not only did Laura's counsel, presumptively with her assent, post his 100-plus page response on his personal Twitter account, which included the same medical records Laura demanded to be protected by this court, and both expert reports contrary to court order. But they have also provided commentary that the expert report prepared by 2 medical school obstetric professors was a soft 2 on a scale of 1 to 10 for Laura, 10 being bad, which is so stupid. Exhibit 5. Laura's counsel, ostensibly with direction from Laura, continues to espouse his theories on the case and publish Laura's private medical records online and on his firm's blog. This, contrary to Laura's repeated filings and assertions in the order of protection hearing and before this court that she was entitled to this court's protection in the light of negative public in reaction to reaching out to the media, the Sun, and other tabloids. Moreover, her counsel not only shared her medical records on his personal Twitter, but also engaging in discourse about elements of the case the parties were ordered not to disclose with a private individual alongside his client. Exhibit 6. This flies in the face of the court's order that no party shall disclose outside of themselves any medical or other documents, exhibits, medical records, etc., disclosed between parties. See Court's minute entry dated February 1st, 2024. We saw that hearing. The court said, stop it. Don't do it. Because she accused Clayton of being the one who did it, and he wasn't. He didn't do it, but she said he did. It's always been her. She is the reason we have all of this. 3. Although expert reports have no bearing on the fraud Laura perpetuated on the court in the order of protection at issue, Laura's expert report only shows Laura lied, a minimum by omission, to her own report. Expert report. Laura has admitted to tampering with the sonogram relied on by Judge Duty when he granted her order of protection. This is fraud and evidence tampering. Her expert's report, which appears to rely on fabricated data and omitted medical records, which may also be fabricated, about having her ovary removed, has questionable value. Laura altered a sonogram and used the fake evidence to secure an order of protection. This is fraud upon the court. Just fraud and fraud and fraud. So much fraud. To the extent that this court believes the improperly published expert report is relevant, it should be noted that absent from Dr. Medchill's report is any review of Laura's medical records that show she had an ovary removed in 2016. There is no mention of Dr. Chung Kyle Chan, MD's records for Laura, who reportedly diagnosed her with real ovarian cancer, not something that just may be there, or of Dr. Rebecca Yee's MD records for Laura, who said yesterday, you received this. You received the surgical abortion and the ovary removal. Additionally, all confirmed medical records for Laura failed to mention a missing ovary, which be critical information Laura would need to inform her doctors about as well, according to Dr. Yee, MD. And I already described, I don't know that that really would have changed the information. Because you either are pregnant or you're not pregnant. All the ovary thing would be your chances of getting pregnant. Which can come into play because they're trying to say, you know, she's pregnant all the time, but yet she had an ovary removed, so she shouldn't be getting pregnant all the time. That's why I put my opinion in about how I seem to get pregnant every time I did not use protection. Letter to Laura. At this point, having children on your own would obviously be impossible. What? Okay. I don't know where that came from because it's not impossible. Upon information and belief, either Laura lied to her own expert in the court and the providers, or Laura faked additional medical records going back to 2016 as part of her pregnancy for a relationship con. If a medical doctor said that with one ovary it would be impossible to have your own children, I have concerns with that. I don't care which expert that came from, if it came from an expert. Or if it came from the person who she said removed her ovary. But either way, that's not true. Number 4. The evidence supports the conclusion Laura perpetuated fraud before Judge Duty and this court. The sonogram at issue and the sole reason Judge Judy granted Laura's order of protection did not come from Smile despite its appearance. According to testimony, she changed the top of the sonogram from Planned Parenthood to Smile, amended motion for relief judgment based on fraud. It also, despite Laura's bizarre testimony at deposition, did not come from Planned Parenthood, who noted per our EMR team, the ultrasound provided in your fax does not appear consistent with ultrasound images generated by our practice. This is because upon information and belief, in considering the existing information, it is not really Laura's sonogram, and instead was manufactured by Laura with the intent to defraud the court into believing that Laura was pregnant with Clayton's twins and that she was receiving obstetric care, which has also been confirmed to be false. 5. Clayton is entitled to his reasonable attorney's fees and costs incurred in this action, including all filings related to the motion for relief from judgment. Laura was fully aware of the true nature and circumstances underpinning her perjurous statements, and when she admitted medical evidence on October 6th and October 25th, 2023, she knew she had not received an ultrasound for her alleged twin pregnancy, and that the sonogram she had proffered was, upon information and belief, created by her. She knew the sonogram was fabricated when she deposed Clayton on February 2nd, 2024, yet she presented the sonogram to him and falsely attributed it to Smile. When she was deposed by Clayton in March, she knew she was lying when she said the sonogram was falsely attributed to Smile but originated at Planned Parenthood, a lie which was not confirmed until Clayton received confirmation from Planned Parenthood on April 26, 2024. Clayton has also had to incur significant costs and fees unraveling Laura's ever-expanding web of lies, which include having to defend himself against her malignant filings of the underlying order of protection. Clayton is entitled to his reasonable attorney fees and costs expending defending himself against Laura pursuant to ARS 25-324. Wherefore, Clayton respectfully requests the court A. dismiss the order of protection in its entirety based on the fraud, B. grant leave to Clayton to submit a child doll affidavit, C. award Clayton his reasonable attorney fees, D. order such further relief as the court deems just and includes sanctions available to the court. Respectfully submitted, 30th day of April 2024, and it was sent to the proper people. That's from Greg. Then we have Clayton's verification, which we go over all the time, just saying he believes, true and correct, his acknowledgement. And then here's the fax cover for Planned Parenthood, Orange and San Bernardino counties, California. Receive attached follow-up request on original authorization form, request for records related to Owens v. Echard, see response attached. And then via fax on April 26, 2024. To whom it may concern, we can confirm the records we provided previously include all the information we have on file for the patient identified in your request. This patient had a scheduled an appointment for July 2nd, 2023, but our records show the appointment was canceled. The visit summary provided by the patient would be consistent with a summary generated for a canceled visit. Oh, really? So what she showed us was not confirming pregnancy, but it was just a thing of what it says when you cancel an appointment. Interesting. You've been caught. Per EMR team, the ultrasound image provided in your fax does not appear consistent with ultrasound images generated by our practice. Although this patient was not seen by us, Planned Parenthood, Orange, and San Bernardino counties incorporated for an appointment, there are other Planned Parenthood providers affiliated in our area, and it is possible the patient was seen by a different Planned Parenthood entity, which we would not be able to confirm or speak to. If you have any questions, please do not hesitate to contact PP Planned Parenthood of San Bernardino, Orange, San Bernardino County. Thank you. And then it's signed. Declaration. Custodian of records, Planned Parenthood, Owens or Emily Laura Wilson. Given the date of birth, undersigned, custodian of records, qualified witness. A comprehensive record search was conducted and information already provided was comprehensive. No additional records matching Laura Michelle Owens with the date of birth of May 14th, 1990, were identified. I declare under penalty of perjuries and the laws of the state of California that the foregoing is true and correct. So that was sent over. Planned Parenthood says nope. All right, now we have this fax cover sheet. Good morning. Please see the attached from attorneys Greg Woodnick and Isabel Rainey. Please feel free to contact our office with any questions. Thank you. All right, and then we have over here Planned Parenthood Mission Viejo, Planned Parenthood Costa Mesa Health Center, and Planned Parenthood Westminster Health Center. So these are all in California. She originally said she went to Mission Viejo. It says, Dear provider, this is a follow-up letter confirming that the information previously faxed to our office attached is all of the information you have on file for Laura Michelle Owens, date of birth, and her patient ID. Miss Owens is claiming that an ultrasound was performed on July 2nd, 2023, and was administered by Dr. Mandeep Sidhu in your Costa Mesa location. So she changed it to Costa Mesa and not Mission Viejo. She has provided screenshots of this alleged appointment, as well as a visit summary that contains no information attached. She also provided what she avers to be the ultrasound from the visit. Please note she has testified to doctoring the head of the image to attribute to Smile, but claims she obtained the actual ultrasound from your organization. The alleged ultrasound is also attached to this email. If you can kindly recheck your records using the patient ID number provided to confirm or deny that Ms. Owens, for July 2nd, 2023, was seen in person for an ultrasound, that would be much appreciated. If any additional records come up during your search, please provide those as well. So that is the fax that he sent over. The original letter to your organization that contains the court order for Ms. Owens' medical records, as well as her signed HIPAA releases, is attached for your reference. Please note this cause does not involve fraud allegations against one of the parties, including medical records, doctoring, and manipulation. As such, please assure your custodian of records not only provides the full file, but if there are records that were not produced by your office, submitted by a party through an online portal, that they be clearly identified as such, including the submission date, so that they are not misconstrued as records prepared for by your office. Inversely, if your records search confirms no other records exist, please have your custodian of records provide a basic affidavit indicating their number one, they are the custodian of medical records for the facility. 2, a comprehension record search was conducted and that information already provided is comprehensive. 3, no additional records matching Laura Michelle Owens with the date of birth were identified. Time is of the essence. As such, we are asking that you expedite production of the requested data or confirming the absence of information and provide the same directly to our office. We appreciate your prompt attention to this matter. We will, of course, pay for copies upon presentation of invoices. Signed, Woodnick. Okay. And then we have this one. That is the same thing that he faxed. This is Mission Viejo. Dear provider, HIPAA release regarding a potential patient of yours, Laura Michelle Owens, who also may have used the alias Emily Laura Wilson with the same date of birth. HIPAA compliance release was executed by Ms. Owens. Recorded deposition on March 1st, 2024 for use and cause number. As evidenced by her signature, you have the authority to release Ms. Owens' records from August 2020 to present date directly to our office. The court has also issued a minute entry attached confirming your authority to release records regarding the same. Please promptly provide any or all medical records from that period for any treatment services and communications provided to / with Ms. Owens. This is meant to be comprehensive. Please note that this does not involve fraud allegations of one of the parties, blah, 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 blah. Okay, we already read that part. And then we will be providing the forwarding the minute entry from the court, confirming the authority under a separate cover for now, and because of the time is of the essence, we're asking you to expedite the motions, or the records. Here is the HIPAA release, and it says, I hereby authorize disclosure of the above named individual's health information as described below. The undersigned hereby authorizes Planned Parenthood, Mission Viejo, and its affiliates, I guess, to Woodnick Law, from 8/1/2020 through present, and she signed this on March 1st, 2024. So she put Mission Viejo, and then she said, no, that's not the right one, possibly. That's what it seems like. She gave them the wrong thing. Why give them the wrong one? And then there's the minute entry. There is a letter at the end of this minute entry at 10:30 a.m. This is the time set for status conference regarding respondent's expedited motion to set an in-person status conference. Petitioner Owens is present with the above-named counsel. Respondent Echard is present with the above-named counsel. A record of the proceeding is made digitally in lieu of a court reporter. Discussion is held regarding the status of the case, and counsel for respondent's expedited motion to continue trial and motion for additional trial time filed February 6, 2024. Counsel for respondent addresses the court regarding opposing counsel's failure to provide discovery and disclosure and advises the court of a forthcoming deposition set for March 1st, 2024 at 8 a.m. as the basis for his expedited motion. Counsel for the petitioner advises the court there is no objection to respondent's expedited motion to continue trial and addresses the court regarding the rule concerning petitioner's motion for confidentiality and preliminary protective order filed January 17, 2024. Counsel further advises the court that discovery regarding his client's pregnancy records is forthcoming by the end of the week, which it wasn't. Based on the matters discussed, it is ordered granting the expedited motion to continue trial. It is further ordered vacating the trial evidentiary hearing scheduled for February 27, 2024 at 4 p.m. and resetting same to June 10, 2024 at 8:45 a.m. 2 hours are allotted. The parties and counsel, if represented, shall appear in person before Judge Bada. Where to find additional information and forms, and it tells you where to go. Time for hearing, pre-settlement. Okay. Each party will have about half of the available time to present. Okay. It is ordered with regard to discovery and disclosure requirements. In general, number 1, the court will only set the matter for trial once all disclosure and discovery is complete. Both parties shall provide any additional disclosures as required under Arizona Family Law 49B2 and shall complete all discovery no later than 30 days prior to trial, which is this Friday, May 10th. 2. Any motions other than the motion to extend shall be filed at least 15 days prior to trial. Counsel and both parties if there are no counsel, and assuming that the court has made exceptions based on issues of domestic violence, shall personally meet face-to-face at least 10 days before trial to discuss the resolution and narrowing of all procedural and substantive issues in this case. So June 1st, they're going to have to meet and talk about certain things. Not until then do they have to. 4. The parties shall promptly comply with all requests for relevant information in this case. That means that the parties shall sign all necessary consents and releases reasonably required to obtain relevant documents or records from any financial institute, company, business, medical or healthcare provider, or employer processing any relevant information pursuant to the Arizona Family Law Practice 76.1. Either party may request that the court hold a scheduled conference to discuss the trial, including scheduled witness, the admission of evidence, and the file of pretrial settlements, At least one of the attorneys who will conduct the trial for each party and self-represented parties must attend to this conference and shall follow the rules for pre-scheduling conference statement outlined in Rule 76.1. It is ordered the parties shall file and provide the division and opposing party with a copy of pretrial statement pursuant to Arizona Family Law 76.1 no later than 5 days before trial. So that would be June 5th. Pretrial statement must include the attachment list as applicable. It is further ordered that the failure of counsel or any party to appear at the time of trial or timely present a completed pretrial statement with all attachments may result in sanctions. The sanctions may include the court's proceeding by default based on the evidence presented by the appearing party. Let's see here. The court will decide the issues. Goes over that. Alright, so that's what the order was. And then here's an email to Reality Steve from Greg Woodnick. Steve, as you may know, my office represents Clayton Echard in the residual portion of the paternity matter pending in Arizona. My understanding is that you had communication directly with Owens in the fall of 2023 regarding the alleged pregnancy. I do not know the extent of your communication, and I'm assuming it's related to your role as the media reporter covering Clayton, former bachelor, and Owens, podcaster. Clayton has an ultrasound video that he says Owens sent him digitally on or about October 6th that was addressed through deposition. The ultrasound and email purported to be from Laura and have the subject line ultrasound video proof. Laura appears to be denying that this is her ultrasound and that this was sent to Clayton. Would you consider forwarding me whatever Laura sent you by email? Greg. So he's asking Reality Steve, can you please send me this? All right. So here we go. This. All right. So now we have Reality Steve messaging back, says, here you go. One of the many bizarre emails she sent me that in my mind proved nothing. And no, she never followed up with any sort of defamation suit against me, despite what her subject line says. And this, I believe, was after I'd gone off on her in my podcast, calling her a dumbass and a liar. Oh well, enjoy. And then he forwarded it. And so this says, this is the message that he got. And it was from Laura Owens on Wednesday, October 11th, 2023. Now this is a different email address than her nobody told me one. But she wrote, Steve, I am not a listener of your show normally, but I was told to check out yesterday's episode, and I was stunned at what I heard on your 10-plus minute rant about me. The message that you tried to get out to your listeners yesterday was clear. You don't believe I'm pregnant because of that you think that I have made up and that I was abused in the past, that I shouldn't be doing anything publicly related to self-help, and that I am doing a disservice to women. Yes. Yes, you are. Reality Steve was correct if he said that. All of these things are provably wrong. Are they? Because they haven't been proven wrong so far. I am sending you this email not because I want to be pen pals. Oh, he doesn't want to be pen pals with you. He doesn't need that cray-cray in his life. But because I am required to give you 30 days to retract your false statements before I sue for defamation, since you have made every effort to attack my credibility and destroy my reputation. He has the freedom of speech. He can give his opinion based on what he thinks. What he has seen, he gets to give his opinion about, just like everybody else. We're going off what we believe to be is true. We're not out here stating anything that nobody could come to the same conclusion about. We're not out here saying that aliens came down and took over your body and you're a zombie and things like that, and that you're into Wicca or anything like nobody's saying stuff like that that's just pulled out of thin air. We're basing opinions off of evidence that we have thus far and what we believe is true. And we're allowed to speak on that, whether you like it or not. And destroy my reputation. You've chosen to ignore evidence provided to you, including medical records and legal documents that prove I am telling the truth, and instead have assassinated my character. Where is the proof that proves that you're telling the truth? Because it's not out there. I don't owe you anything, but in order to give you a reason to take back what you said, I am attaching a clip from this weekend of my pregnant belly, a sonogram from last month, and a video so you know it's not doctored, but you can doctor a video. People put in clips all the time of things. Like you take parts of court proceedings, or you take, like, just because you had a video doesn't mean that you didn't doctor it. From my patient portal, from a visit with my neurologist today. She thinks that if you submit a video, that means it's not doctored. Okay. And then it says, which proves that I am, by all accounts, 21 weeks pregnant with twins. Okay, remember this is October 11th. Clayton has seen all of this, and I don't see why it is owed to the rest of the world, but apparently if I don't give it out, I will be treated viciously by the public. Nobody even really had to know about all this crap. But you put it out there. You just admitted that you had to put it out there. Not that Clayton put it out there, but that you felt like you had to because nobody believed you. You know what I also learned? I learned it a couple years ago. But I was watching, I don't remember what I was watching, but maybe it was like Catfish or something. But that just because you FaceTime somebody, or somebody like that, somebody can fake being on FaceTime with you. Like you can actually be on FaceTime with somebody and that not actually be the real person, because people are like, oh, why don't you FaceTime them to see if they're real? But apparently you can fake that too. Like, apparently in technology world, you can fake anything. AI is an example of that, but that's scary. That's scary. Some things it's used for good, but a lot of people use things for evil in this world, unfortunately. But yeah, it's just, but she's not very bright. So your allegations about me not being a victim of domestic violence when abused by both of my exes was witnessed by strangers who had given public statements in both situations, were uninformed and made malicious. I know you have seen the witness statements, which is why I'm so confused as to why you would question my history of domestic violence. I even have the photos of the injuries I suffered at the hands of the exes I was with for 2 years that are part of his DV file in San Francisco. And while the second ex didn't physically hurt me, he did tell me to take an abortion pill, or I'll call the cops, in writing, which by all means is abusive. How is somebody saying, so now guys can't even write in a text when a girl says, do you want me to get an abortion? The guy cannot say, take the fucking abortion pills. I don't want the baby. Because then they can be accused of being abusive. He said it more than once. Oh, who cares? The fact that a judge was like, okay, he told you to take abortion pills. Like, he is obviously a perpetrator, a predator. Like, what has this soft world come to? That somebody telling you to get an abortion when you're asking them if they want you to get one is considered abuse. People that didn't get beat as a child, I'm guessing. As you know from listening to the audio on my calls with Ravgen, the results are not back yet. Clearly, I do have fetal DNA in me. Where? No, you do not. Admit, after the first test, it said no. Then whatever happened to the second test. But guess what? The third test, which is the second one we have results on, also said little to no fetal DNA. Did we need 8 of those? How many was it going to take? Were you just going to continue going on and on and on and on about having one? No. I think 2 is good enough. I do have fetal DNA in me. It makes you act like a baby. And Clayton's mention of little to no fetal DNA was in the sample, as the lab said, which didn't mean I have little to no fetal DNA in my body. So they just write in results for lab tests that doesn't mean what it says what it says. So does that mean when a lab test says pregnant that does not mean that I am pregnant? When it says I have little to no fetal DNA, that doesn't mean that I have little to no fetal DNA. Because they write what the labs don't say. They don't write what the labs do say. Gosh, didn't y'all know that? I hope I am not forced to file a lawsuit for defamation, as no desire for money from you or Clayton. I just want a retraction and an apology. All the best! And then check out my podcast, check out my TEDx, check out my Chicken Soup for the Soul, and check out my Quartet Farms that me and my family own. Here you go. Ugh. God, she is insufferable. Alright, here is what... Okay, so she's using this other one, not her Nobody Told Me one, to send these, which I don't know if that's what Dave sent, if when she messaged Dave, if it was on that one or what. This one was to Clayton, and medical confirmation diagnosis supports my pregnancy. Saturday, October 14th, 2023. Clayton, this afternoon, I opened the file labeled sonogram September 5th, 2023 video, and it matches up with the still photo that Dave sent me, which I told him was not my ultrasound. I stand by that 100%. I'm 100% sure you won't believe me, but I had a different sonogram video with that title that I uploaded weeks ago. Greg went into my Dropbox, my computer, and changed it. So he went into your computer, huh? Not just online. He went into your computer and changed it. So Greg broke into your house to get on your computer while you were not there, or while your computer was with you, or while you were sleeping, and changed it? That doesn't make any sense. And you're speaking in percentages, which makes me automatically not believe you. My Dropbox was open to everyone to edit rather than just view, which I didn't know for about a week. Oh yeah, you're so oblivious. He would benefit so much if he were able to throw this on me, which he won't be able to do. If neither you nor Dave posted the costume photo with me holding the specific sonogram image of our son, then Greg went into my computer and took it. No one else was sent it. So when she's saying she told the judge that nobody else was sent this, but she stated here that Clayton was sent it and Dave was sent it. And if Dave and Clayton didn't do it, then Greg got on her computer and did it. She's saying on my computer. Or she says in my computer. Which to me sounds like Greg and Greg. 1G and 2G. Or wait, hold on. No, she's talking about 1G. We're not talking about Whitnick in this. So just Greg. Got it. Went in on her computer. Just snuck in there in the middle of the night and took it. No one else was sent. I am sending you what I am sending to Detective Craig Reedy about all that connects to Gillespie to this. What in the conspiracy theory are you doing? Wasting police's time. I would like to see what Detective Craig Reedy's report about Gillespie getting in her computer, getting on her computer, and taking things. I bet he didn't find anything. I am filing harassment charges against him, which is a serious felony. So is fraudulent documents. You accuse everybody of these crimes that you are committing yourself. Project much? I would hope that you might understand the mix-up with the sonogram videos based on your friend Greg's history. Greg's history is said by a person who has zero credibility. So we don't know what Greg's history is if we just go based on Owens. Because Owens says a lot of stuff. Most of it ends up not being true. I am still very much pregnant. And it's too much for me to read what has been written about me and what armchair psychologists think when the reality is that I am still pregnant, and that's it. I think you were very, very high that night and forgot that when I was on top of your crotch, or couch, sorry, couch, crotch, whatever, she was on both, I think. You begged me to let you put it in for 30 seconds, then 25, then 20, then 15 to 10, and I said no each time. Okay, so October 14th, she mentioned that she said no. Then, I thought you were just fingering me. Ugh, but you stuck it in briefly. You can't tell the difference between a finger and a thingamabob? Oh my God. I'm sorry. It's not the same. It doesn't feel the same. And never in the history does somebody think they are being fingered while somebody is penetrating. It doesn't feel the same. Maybe it's just me. I told this story to family and my inner circle of friends the day after we hooked up, And nothing about how I have told the story has changed since then. Oh, dear Lord, has it changed? It has changed so much. Maybe not from October 14th, but let's say from the 14th of October 2023 to present day, everything has changed. That's exactly what happened, and I'm not making this up at all. And I have been asked why I haven't said anything since this started. I know we technically had the same amount of weed according to you, but I think you were a lot higher since you started a long time before me. Again, I don't expect you to believe me. Well, good. At least you're on the same page. I realize that a neurologist is not an OBGYN, but that is the most recent doctor who saw me and who clearly agreed with the fact that I looked 21 weeks pregnant. He didn't say you looked 21 weeks pregnant. He said you reported that you were 21 weeks pregnant. But okay. As you can see from the screenshot, she referred me to a different specialist and diagnosed me with epilepsy during pregnancy. So believe it or not, I am still very much pregnant, and you are welcome to go with me to the doctor if you would like. All of your celebratory videos are in poor taste when testing is by no means completed, and when I fully expect the test results to come back with you as confirmed the father at the end of the week. But it said little to no fetal DNA, so that didn't happen either. Wishful thinking. As I've said, I would have no reason to continue communication with you if I weren't pregnant, since I want nothing from you at all. Except you want somebody to love you for the rest of your life, and nobody wants to right now. Therefore, I hope you believe what I told you in the first 2 paragraphs. All the best! Ugh. Alright, and now we have 2 Owens from Patrice O'Malley. Okay. Sent on behalf of Joseph W. Cotchett. Dear Laura, thank you for the note. It is an extraordinary story with Gillespie. I'm glad you are pursuing charges as their conduct is outrageous. If we can help in any way, do not hesitate to call. Best regards, Joe. And he's an attorney, I guess. All right. All right, and here's the thing that Owen sent to Patrice O'Malley. Hi, Patrice. Hope all is well. I'm happy to report the default judgment was granted in my favor in the abortion coercion lawsuit I filed against my short-term boyfriend, Greg Gillespie. I am pursuing fraud charges as a result of fraudulent emails that he concocted and were purported to have come from me. This is on 9/25/2023, so September 25th, 2023. He has apparently doctored an ultrasound image from the internet and attributed it to me. I have seen no proof of it. However, his attorney, in an attempt to intimidate me, claimed that he had sent it to Joe and that Joe had presumably informed me of the counterclaim against me for fraud. As baffling as this is to you, it's equally baffling to me. I deeply apologize for their attempt to involve Joe and your firm in this and would really appreciate any information you can give me on this, as I have my doubts about whether he and Joe had this conversation. All the best, Owens, sent from her iPhone. Okay. So what I haven't noticed is this lawsuit for Greg doing this fraudulent stuff. Why hasn't she filed that? Because she knows that that's not going to go anywhere, because somebody in forensics can look at the metadata and determine she is a liar. And that's aiming for more jail time for Owens. But go ahead and do it. Try it, Owens. See what happens. You're getting a little too close to the fire. All right, then we have amended motion to withdraw as attorney of record for the defendant without consent. This is Owens v. Greg Gillespie. And this was filed February 16th, 2023. Arizona rules for allowing the firm of Woodnick to review. So this is Woodnick withdrawing as attorney of records for Greg Gillespie. The reason for this motion is the breakdown in communication between attorney and client has occurred such that the attorney cannot proceed with client's representation. The client has failed to substantially fulfill an obligation to the lawyer regarding lawyer services and has been given reasonable warning that the lawyer will withdraw. And the withdrawal can be accomplished without material adverse effect on the client pursuant to ER 1.16. Undersigned counsel withdrawal in this matter is requested. Counsel undersigned hereby certifies defendant has previously been notified of the status of this case and is aware of his duty to communicate with the assigned arbitrator, Ms. Jackson, the last known mailing address. Wherefore, respectfully request an order granting the withdrawal from further representing Woodnick, or Gillespie, sorry, and that's by Woodnick. Dave Neal. Owens says, okay, thanks, I would appreciate it. The last imaging I had was troubling to me because I thought the boy's profile looked kind of weird attached, but the sonographer didn't say anything. I guess I just don't know how to read these things, and I'm probably overanalyzing. The girl looks fine to me. All the best. You would think, after the amount of pregnancies and ultrasounds she has supposedly had, she would know how to read a sonogram. And they explain those things to you as well. October 12th, 2023, Dave Neal wrote, working on locating the source. I'll let you know when I found out. October 12th, wrote, I didn't even see that it had my name on it. Did Greg send that to you? I'm guessing. Owens wrote back and said, no, that's not mine. Dave Neal wrote, hey, Laura, please let me know. I just want to make sure someone isn't floating around doctored or false ultrasound sonograms of yours. Is this sonogram you have referenced of yours that you don't want shared? Cheers, Dave. He also wrote, hey, I was actually just going to ask if you wanted me to share that. I wasn't sure. I appreciated you letting me know in advance. I actually I'm going to be in Scottsdale for a week for some separate business with my wife. Hope weather isn't too hot this time of year. See, Dave Neal is being very nice to Owens. And then it says, Dave also wrote, I hate to throw the threat of a lawsuit in again, but I saw Laura wrote, Dave, I hate to throw the threat of a lawsuit in, but I saw on Reddit that you are looking for an expert to review my sonogram. It is highly illegal, a HIPAA violation, for you to be wanting to share anything related to my health without my permission, let alone trying to share it with strangers on the internet. I suggest that you delete that post and any evidence that you are trying to gather as my sonogram image and video are 100% real and verified. Who verified them? Because we've seen no verification from anybody. You do not have my permission to be sharing phone calls, medical records, etc. with public audience. I have shared them with you simply so you can keep them in mind with your audience, not so you can analyze them. You should have thought about that before you shared them with people, because it is no longer private. And you didn't say that when you sent those to him. And then this is the one she was talking about, the gestational age 17 weeks, 0 days, which medical experts have already said this is not what she would be at that point. This is the one that Dave, Neil, and Megan were talking about last week, with it being on this table, that we think that it is from possibly the sisters' sonogram. It was done in 2023. And this gestational age was 21 weeks and 3 days. And this is like a strip, like it's, you know, done out. What you can notice though is in this picture, even right here where it's cut off in the first picture, where it's got all this information and stuff, that stuff isn't in any of Owens' stuff. But if you look at like what my daughter's sonogram stuff is, that type of stuff is on there. And then they redacted the picture of the baby. But if you watched Dave last week, you saw what it looks like. And she was talking about the nose, that it looked like it didn't have a nose. Well, depending on the angle that the baby is in, and you can get the wand and stuff like that, sometimes it doesn't look like there's like a nose, or you can just see two holes, but you can't see the actual formation of the nose depending on how the baby is positioned. It may not look that way. Sometimes it looks just like a skeleton, which is sometimes really creepy. But nobody was like, oh, one baby has a nose and one baby doesn't have a nose. It looks like the scary thing. I don't know who it is. Which horror person doesn't have like the nose? Is it Freddy Krueger? I don't know who doesn't have the nose or something, but there's one scary person out there that their face does not have a nose. It's just nose holes. But anyways, I digress. All right, then we're going to go over here to Gingras' posts. It says, several people asked for copies, so I'll save you the trouble. Here's everything filed yesterday in Owens v. Echard. I might blog this later, maybe not. It's Saturday after a long week, and my small brain needs a break. Well, at least we all agree you have a small brain. Another post, he says, big if true, but honestly, I don't want to suppress opposing views. But you do. And you talk about, oh, you don't want people to be jerks and jackasses and stuff, but you're like one of the biggest ones of all, but you can't handle it if somebody like comes back at you. Wussy. Debate is the greatest tool in our search for the truth. It's not much use if I'm just debating with myself. You seem to debate yourself in your head constantly. Might need to go get it checked out. Maybe this is a glitch or a sign of something more ominous. The search continues. Hashtag justice for Laura. Nobody's putting that except for you. But okay. Then it says, just filed 5 minutes ago. Expert reports from both sides are exhibited. Clayton's is 9 pages. Ours is 125 pages. If anyone wants a link, go hug your dog and stop obsessing over this stuff. Have a nice weekend, except for never mind. And then that is the petitioner's response to response. Okay. In fairness, both experts' reports are similar in length. The reason ours is so much longer is because we disclosed everything the experts looked at, which the rules require. But you didn't disclose. You didn't disclose everything. You left out some big things that your expert can't look at. But okay. Small OBE update. I'm off work the next 2 days for important social functions for a friend. No motions until I'm back. But I received Clayton's expert report yesterday on a scale of 1 to 10 for Laura. 10 being bad. It's like a soft 2. Barely. More to come soon. Oh, and Clayton has our expert report from the guy who probably has more OBGYN experience than anyone in Arizona. His opinion is on a scale of 1 to 10, 10 being good for Laura. Let's just say it's not a soft 2. The report will be made public in due course. Also says, I'm not blogging any further about this case for now. Reason, my investigation is now complete. I'm drafting 2 new motions and will be filed this week, hopefully Wednesday. I said the truth will come out in the end. That is coming this week. The truth that your client is a liar? Because that's what came out the week that you posted all this. That she's a bigger liar than we thought. All right, Isabel Rainey, the facts versus your interview with Reality Steve. Says, Gingras now bullying someone who came on my podcast a couple of months ago. FYI, don't want my name to use, but FYI, feel free to send to Dave. Okay. I am Laura's attorney in the paternity matter involving Clayton Echard. I have no idea who you are, and I have no idea what you know about this case. Laura did CC on her email to you, and she forwarded your response below. That's all the information I have about you. Based on what you have said here, it sounds like you are part of the Clayton Echard cult. Hello, my fellow cult members. Wave in the chat if you are a Clayton cult member. If that's not true, my apologies. But despite only being involved in this case for less than 30 days, can you believe it's only been a month of dealing with him? And we've been dealing with this case for several months, but it's been so busy since he came on. And he has not helped his client at all. He has made things 10 times worse than they were originally. And if I was Owens, I'd be pissed about what all has been found out since he came on. I have never seen such a shocking level of cult-like mass hysteria in my life. Seriously, it's both shocking and disturbing. I have been practicing law for more than 20 years, and I have handled tons and tons of cases that involved way more animosity than this, but I have never seen such dishonesty and delusional thinking from an opposing party. Never, not even close. This one takes the cake. If everybody is so delusional, why have other attorneys gotten off this case? Are they delulu too? Because I'm thinking you, Owens' parents, don't know about her sister. Y'all are the delulu ones. This one takes the cake. It's like Clayton's followers have created this fake fantasy world where Clayton is the hero, Laura is Satan, and they cannot accept any evidence to the contrary. We would if it was backed up by facts. We're not just going to take random stuff because your client likes arts and crafts. Again, I have no idea what you previously said about this case. I don't know what your agenda is here, but your email below is clearly an example of broken cult mind mentality that is permeating in this case. It's sad and it's annoying that people actually live this way. I rather live the way I'm living than live the way them two are living. I'm talking about this line specifically. It is very clear that the easiest way to prove a pregnancy is not to hire a retired doctor to review medical records you've proved with a clear request for him to support your case. No rational person would say this. This is cult speak. If whoever sent this, I don't know who they are. I really hope it's not anybody here. But whoever sent this, you can hire retired doctors to review things. Many experts are not necessarily in the field that they're experts for now. They worked in the field for a long time, but now they do expert testimony and things like that for cases. That they're not actually working in the field. They just go cases to cases to cases. That's not abnormal. So if you think this way, please revert that that's not accurate. If you bothered to review the packet of information sent to Dr. Medchill, you'd see two things. First, Dr. Medchill is 100% neutral, absolutely top-level expert. He was the chairman of an OBGYN department at one of the largest hospitals in Phoenix, which he didn't put on his CV. He has personally delivered more babies than any doctor in Arizona. That is what you think. That doesn't mean that's the truth. His credentials in the first place are beyond question, whereas Clayton's experts have far less experience. Whether they have more or less experience, the problem, as I said in the last video, with Dr. Medchill's opinion is not Dr. Medchill's fault. Nobody should be mad at Dr. Medchill. He was asked to give what he believed based on the information he was given. But we know Medchill was not given all the information. He was not given all the facts. And if he was, maybe his opinion would be different. And if there's cross and he comes to discover those things, his answers might be different than what he originally said. But let's not blame Medchill for giving an opinion on what evidence and what was put in front of him, because it's not all based in facts. There's stuff that's omitted, and so forth. Okay? Second, at no point was Dr. Medchill ever asked to support Laura's case. Dr. Medchill has never met Laura and has no reason to be anything but honest but what he thinks happened here. He's not doing Laura any favors. He is simply a lifelong medical professional who is expressing an opinion about an area in which he is a subject matter expert. Correct. And he went with the facts that he was, not even facts, he went with the information he was given. Gingrich goes on to say, in fact, not only was there no pressure on Dr. Medchill to support one conclusion on the other, he was specifically asked if he believed Clayton's position was correct. He could have said whatever he wanted to in the response to that question. He could have. But you know what would have happened if he would have sided with Clayton? They would not have hired him. They would have gone and found another one, and we would never know about Dr. Medchill's opinion. He could have said whatever he wanted to the question. He believed Clayton was right. He is believed Clayton was right, as you clearly do. He would have said so, but he didn't, because Clayton is 100% wrong. These experts are not 100% wrong or 100% right. Different expertise, certain things, and they both got different information. You're speaking in percentages once again. I don't believe you. Percentage speak is a lie. And it's worth nothing that Dr. Medchill was paid in advance for his work. He was paid before he ever rendered any opinion at all. Again, that simply shows his neutral profession, who has nothing to gain from his opinions here. One other response to your snide remark about how hiring experts isn't the best approach. We only hired an expert after Clayton disclosed he had hired 2 experts. Got that? Dr. Medchill is a rebuttal expert. We only hired him for a narrow purpose of responding to Clayton's experts, who, by the way, do not support Clayton's position at all. Yes, they do. You just don't know how to read. So if you really think calling experts is not the best way to address all this stuff, you should probably criticize Clayton for hiring 2 experts first, thereby focus us to respond in kind. Anyway, having debate many members of Clayton's cult, I realize that logic and sanity have no value for them. So please just ignore this message and go back to believing whatever makes you happy. Now, I can see Clayton needing to hire experts. Why? Because he didn't go to any of those doctor's appointments. He hasn't seen a doctor. He was not the one pregnant. He has to hire somebody else. What Owens could have done is used an OBGYN that she went to confirm. But she doesn't have one of those. She doesn't have a real doctor that she saw to confirm all this stuff. So she needs somebody else. She needs an expert witness who has never seen her, didn't deal with her at all during this pregnancy, this so-called pregnancy. That's why she had to hire an expert. She should have just had an OBGYN that saw her, any of the many that she said she saw. Those should be the ones coming on the stand, not somebody who has never seen her or dealt with her in the pregnancy. That's probably what the person was saying. Maybe they didn't say it so well. But that should be something. If you have a doctor that actually saw her and can confirm stuff that is true in this case on Owen's side, why would you not use that person as opposed to somebody who hasn't dealt with her? That's the point we're making, Gringus. I don't even care what your name is. You're not worth pronouncing your name correctly, and to be honest. All right, and then we have MedChill's disclosure. Do the medical records attached to Owen's affidavit something indicate that she's not pregnant? In or around August 2023, words is any information or evidence in the records which is inconsistent with Owens being pregnant during the time period. So that was a question. All right. Then we have, this was to Owens. Don't know who it's, I guess maybe Reality Steve, but I don't know. It says, as you may remember, my latest book examines moral courage and the importance of speaking up in the face of wrongdoing, even when it is hard. I'll repeat what I said on that podcast, which is that I really hope you are getting some help. It's very clear the easiest way to prove a pregnancy is not to hire a retired doctor to review medical records you've provided with a clear request for him to support your case. I'm surprised that you want that point repeated publicly in a courtroom. You have the option to do the right thing here, even if it is hard, and to take responsibility for your actions and express remorse. Best. Let's see here. It says, Dear blank, for months I have been haunted by your comments on Reality Steve's podcast, grappling with the pain they deepened during what has been the worst period in my life. Dr. MedChill, a respected retired OBGYN who delivered over 22,000 babies during his career, recently reviewed my medical history and confirmed with 99% certainty that I was indeed pregnancy. I am only writing to you now to attach his report and prove that I was telling the truth all along. He is going by what you told him, and what you tell him is not true. And 99%, guess what that leaves? A 1% chance you weren't. He didn't speak in 100%. During your conversation with Steve, you said I was fabricating both my pregnancy and my claims of feeling suicidal. The gleeful and giddy way you spoke about my mental health stripped away any semblance of empathy I once admired in you. It seems the allure of a high-profile platform like his blinded you to the most basic tenets of humanity. You, right now, don't deserve decency because you haven't been decent to anybody else. I like that people, like when people are like, oh, I want you to treat me like this, treat me like this, treat me like this, but I'm going to treat everybody like shit, and I'm going to lie and con my way to get what I want. Because I'm a 2-year-old who throws a tantrum, who has parents that give me whatever I want when I want it. Comments like these present as a professional insight shattered me. Is she actually having suicidal ideations, or is she understanding that by saying she's having suicidal ideation, there's going to be a win? If she's really in crisis, why is she using it to manipulate situations instead of seeking help? Her claims are convenient excuses, aren't they? Designed to garner sympathy and manipulate emotions. Well, that's what it seems like, Owens. You use things to throw your tantrum to get what you want. You did it with Maraschini, you did it with Greg Gillespie, you've done it with Clayton. And now you're trying to do it to the public who do not believe you. And it's not gonna work. Nobody is falling for your shit anymore. You remain the only well-respected professional who has publicly spoken about the situation, and with that came a responsibility that was not met with the gravity it warranted. Your words have not only been quoted by those looking to discredit and mock my experiences, but have also given ammunition to the conspiracy theorists who use your words as proof of my alleged deceit. If you had doubts about the truth, you should have addressed them with me before you publicly discredited me. Why? Why would we want to talk to you? So you can threaten so you can threaten lawsuits? You knew how to reach me, having been a 2-time guest on Nobody Told Me. Oh. See, I don't even know who this is referring to right now. But I want to go find whatever episode this is. But they were a guest twice on Nobody Told Me, and apparently were a guest on Reality Steve. Who did this? A professional. You could have verified the pregnancy yourself, as I would have simply given you the log information. Nobody, listen, Laura, come in close, turn the volume up so you can hear this. Nobody wants your Banner Health patient portal login information. Nobody. Nobody wants to see a P-stick test that says you're positive for HCG, which can mean you're pregnant, but it can also mean other things. Nobody. You cannot say nobody told me this, because I'm telling you right now, nobody wants your Banner Health P-stick results. Period. This letter isn't a request for an apology, as an apology can't reverse the effects of what has already been broadcasted. Your conversation with Steve has reverberated in my mind for months, serving as a constant reminder of how my genuine pain has callously dismissed the subject to be unfounded doubt. Your choice to speak with me in a manner you did neglect the very essence of psychological practice, to first do no harm. It wasn't just a professional failing, but a human one. Who are you to speak about any of that? We have the right to our opinions. She has the right to her professional opinion. Because you haven't proved jack squat. I don't know why this has to be said 20,000 times by so many people. And I don't know if it's going to take a judge going in on you to get the point across that you can't do this. Why is somebody always mowing when I want to record? This is not okay. I think they do it on purpose, but they ruin my rant. Please keep this email between us and don't share it with people who have made my life a living hell for the past 7 months. Owens, you are the one who has made your life a living hell. Had you not done everything that you have done thus far by doctoring evidence, none of this would be happening. Had you come out, or still come out, you can still come out and say, you know what, it was a lie. But you can't do that. Attached is Dr. Medchill's report, which I hope serves as a stark reminder that I was telling the truth about my pregnancy all along, and that your flippant remarks on my mental health crisis are not only misguided, but almost pushed me over the edge. Here she is threatening suicide. It almost made her commit suicide. It almost threw her over the edge. All the best. And then here's all my stuff. And she has Liz Mack Investments now. It is so ridiculous that any of this is happening. An expert report from somebody who doesn't have all the information that he should to make an informed expert opinion proves nothing right now. If you had shown in that expert report that he had all your correct medical history and all the correct facts and documentation, then maybe that would put some more oomph behind Medchill's report. But it's not Medchill's fault. It's yours and your attorneys. And you are making these attorneys stand up and lie, knowingly or unknowingly. I don't think the previous attorneys were doing it knowingly. I think they tried. I think they legitimately believed you. And as soon as they realized that you were full of shit, they got off the case. And then you found somebody that seems to be like you in your beliefs. And I think he is knowingly lying. He can try to say that, oh, I didn't know, oh, I didn't know, oh, I don't know. But he does know. And that what he's doing is unethical. And you're not supposed to do that as a licensed bar attorney. But yet here he is, feeding this bullcrap to everybody. I don't know if it's going to take going to jail for you to learn your lesson. But something needs to happen. That is the end of that motion and the end of this video. If you like this video, hit like, share it with other people if you want to. But we end with our quote of the day. Personal accountability requires mindfulness, acceptance, honesty, and courage. And something that Owens needs to do is take accountability. She needs mindfulness. She needs to accept she needs to accept personal responsibility for what she has done. She needs to be honest. And yeah, in this big of a hole, it's going to take courage. And if you come out and do it, you might gain a few more points. If you come out, because I know it's going to take a lot of courage for you to come out and say, I lied. But if you can take accountability and admit to your wrongdoings, which are a bunch, that shows growth. And we would be able to commend you on that. I don't see that day ever coming, but it's something that needs to happen in this case. Everybody out there, take accountability for your actions. Own it, apologize or accept it, and move on. Because we learn from our mistakes. We don't keep digging our hole deeper and deeper and deeper. Own it and move on. That is an amazing characteristic to have. And makes you a better person if you can do those things. Even if it's the first time in your life that you do it. You can grow and be better from this day forward. Hit subscribe for more videos in the future and turn those notification bells on if you want to be alerted to when they come out. I will see you in the next one. Bye.